Question 1. If a prospective buyer asks the listing broker whether a previous resident of the property died of AIDS, the broker A. must truthfully answer the question, B. can decline to answer the question, C. refer the prospective buyer to another broker, D. both A and C. Correct answer is B. can decline to answer the question. Owners and their agents do not have to voluntarily disclose that a person who lives or has lived on the property suffers from acquired immune deficiency syndrome, AIDS, or has died from it. If a potential buyer asks a direct question about an AIDS-related question concerning the property, it is recommended by the California Association of Realtors that the agent should indicate that any such information, if known, is confidential and private. Question 2. The main types of easement. A. Easement in gross, B. Easement in particular, C. Easement appurtenant, D. both A and C. Correct answer is D. both A and C. Easement appurtenant is an easement that benefits a specific property. This is the most common type of easement. For example, a property owner might have an easement appurtenant that grants them access to a private road in order to reach their landlocked property. Easement in gross is an easement that benefits a person or entity, not a specific property. Easements in gross are less common and typically require a very specific purpose. For instance, a utility company might have an easement in gross across multiple properties to allow them to maintain power lines. Question 3. A listing agent can be A. Seller's agent only, B. Buyer's agent only, C. Dual agent, D. None of the above. Correct answer is C. Dual agent. Although the listing agent contractually represents the fiduciary interest of the seller, an inadvertent dual agency is sometimes created through the conduct of the agent, leading the buyer to believe the agent represents him as well. This underscores the importance of following the agency disclosure requirements. Question 4. Which of the following most resembles the relationship between a broker and seller? A. Broker and salesperson, B. Trustee and beneficiary, C. Mortgager and mortgagee, D. Vendor and vendee. Correct answer is B. Trustee and beneficiary. A broker is like an agent, while the seller is like the principal to whom the agent owes a duty. In the closest comparison, a trustee is like an agent working for a beneficiary, or the principal. The other relationships, broker-salesperson, employer-employee, mortgager-mortgagee, borrower-lender, and vendor-vendee, seller-buyer. Question 5. For tax purposes, depreciation deductions are based on the A. Value of an asset over its useful life, B. Future contract rent, C. Physical life of a property, D. Actual life of the property. Correct answer is a value of an asset over its useful life. How depreciation is calculated determines the depreciation deduction on a tax return in any 1 year. Depreciation is defined as the value of an asset over its useful life, the period during which a property is expected to be usable for the purpose acquired. Useful life may or may not correspond with the actual physical life of a property. Question 6. Which of the following can conduct escrow business? A. A foreign corporation, B. A real estate broker, C. An attorney, D. Any of the above. Correct answer is D. Any of the above. Any of these persons or organizations may function as an escrow agent. Question 7. In the U.S. government survey and township system method of land description, townships are A. 5 miles in diameter, B. The length of the baseline meridian multiplied by its width, C. 36 square miles, D. The amount varies from county to county. Correct answer is C. 36 square miles. Also called the rectangular survey system, this method of property description uses grids of squares called townships which are measured and numbered in each direction from the point of intersection of the baseline and meridian. Each township is 6 miles by 6 miles, 36 square miles. Question 8. According to a deed of trust, the trustor is the person who A. lends the funds, B. signs the promissory note as its maker, C. extends credit, D. holds the funds in trust for the borrower. Correct answer is B. Signs the promissory note as its maker. The truster receives the funds or the extension of credit, then signs the promissory note as the maker. Therefore, he becomes liable for repaying the loan. Question 9. A purchase money mortgage refers to A. When a buyer takes out a mortgage on the property being purchased to secure the loan. B. When a buyer gives the seller a mortgage on the property being purchased and pays the sale price in installment payments. C. A soft money mortgage. D. All of the above. Correct answer is D. All of the above. A soft money mortgage is so called because the borrower receives credit instead of actual cash. When the borrower receives cash, as in a bank loan, from the lender, it is termed a hard money mortgage. Question 10. A real estate broker may act as an escrow holder, without having a California Department of Corporations (DOC) license, if the broker A. is a party to the transaction, B. has the consent of the other parties to do so, C. is performing an act for which a license is required, as the listing or selling broker, D. either A or C. Correct answer is D. Either A or C. Brokers who do act as escrow holders without a DOC license must still comply with all of the agency's regulations. Question 11. A homeowner deciding whether to add an outdoor patio to his home consults an appraiser. That appraiser's recommendation will be based on the principle of A. Regression, B. Progression, C. Contribution, D. Substitution. Correct answer is C. Contribution. The principle of contribution, also known as the principle of marginal productivity, is a real estate appraisal principle that states that the value of a property component is based on its contribution to the total property value. It will help decide whether the value added by the patio is greater than the cost of building it. Question 12. A life estate whose duration is measured by the life of someone other than the estate holder is called a life estate pure autre vie, B. junior life estate, C. term tenancy for life, D. a life estate must be measured by the life of the holder. Correct answer is a life estate pure autre vie. A life estate is an interest in land with a term measured by a human life. The holder possesses the property as long as she lives, with the property then reverting to the original owner. Usually, the measuring life will be that of the property recipient. If not, if is a life estate pure autre vie, for the life of another. For example, a grantor might set up a life estate pure autre vie to allow their child to live in the family home while their spouse is still alive. The term pure autre vie is French for another's life. Question 13. RESPA's purpose is to A. aid consumers to become better shoppers for settlement services, B. provide low-income property buyers with subsidies to help pay closing costs, C. eliminate kickbacks that unnecessarily increase settlement services costs, D. both A and C. Correct answer is D. both A and C. RESPA stands for Real Estate Settlement Procedures Act, which is a federal law that requires mortgage brokers, lenders, and servicers to disclose costs and expectations to borrowers about the real estate settlement process. RESPA was passed in 1974 to protect home buyers and sellers, and to provide consumers with improved disclosures of settlement costs. RESPA typically covers the following: title searches, title examinations, title certificates, title insurance, attorney services, property surveys, credit reports, inspections, and mortgage origination. Question 14. In appraisal, the reproduction approach uses this method to examine separate items of construction to build an accurate estimate of the building's total value. A. Quantitative survey method, B. Total cost method, C. Duplication method, D. Comparison method. Correct answer is a quantitative survey method. Quantity survey is the most reliable method for estimating the cost of replacing a construction improvement. It involves the itemization of all building costs, direct, like materials and labor, and indirect, taxes and insurance, and then totaling these expenditures. This method should be utilized by an appraiser well versed in construction techniques. Question 15. Which is the most significant factor when planning for a subdivision? A. Location analysis. B. Market analysis. C. Community development analysis. D. Cost analysis. Correct answer is B. Market analysis. Market analysis is the more inclusive term. It includes the other options. Question 16. With a dual agency established in a 1 to 4 unit residential sale, the broker and her agent may provide information regarding the from one party to the other. A. Prices of comparable homes. B. The highest amount that a buyer is willing to offer. C. The least amount that a buyer is willing to offer. D. None of the above. Correct answer is A. Prices of comparable homes. Comparable home prices relates to information that can be shared, while personal financial information cannot be. Question 17. The promise given in return for an offered promise in a bilateral contract is A. Acceptance. B. Obligatory trust. C. Partial performance. D. Consideration. Correct answer is D. Consideration. Consideration can be in the form of money, property, or a promise, not just partial completion of the promised action. In a bilateral contract, both parties make promises to each other. Consideration refers to the legal value that each party exchanges in return for the other's promise. Here's a breakdown of the other options. Acceptance simply signifies that an offer has been received and agreed to. It's a step that occurs after consideration is established. Obligatory trust is not a typical term used in contract law. Contracts create obligations, but not necessarily trusts. Partial performance can sometimes be considered in complex contractual situations, but it's not the general requirement for consideration. Question 18. Which of these types of deeds includes a granting clause, but no warranties? A. Grant deed. B. Quitclaim deed. C. Deed in lieu of foreclosure. D. Trustee's deed. Correct answer is B. Quitclaim deed. A grant deed includes a granting clause and also offers warranties from the grantor about the ownership and condition of the title. Deed in lieu of foreclosure transfers ownership from the borrower to the lender to avoid foreclosure proceedings. It typically includes a limited warranty from the borrower. Trustee's deed is issued by a trustee following a foreclosure sale. It conveys ownership to the winning bidder and usually includes warranties related to the trustee's actions during the foreclosure process. A quitclaim deed simply transfers whatever ownership interest the grantor has in the property, without any guarantees or warranties about the title's condition. It includes a granting clause that conveys the property to the grantee, but avoids any responsibility for potential title issues. Question 19. A listing is what kind of agency? A. Executive agency. B. General agency. C. Special agency. D. Dual agency. Correct answer is C. Special agency. Specific tasks, such as a listing, a contract between a property owner and an agent authorized to obtain a buyer, are performed under a special agency. Question 20. Which of the following would make it impossible for a claimant to acquire real property using the method of adverse possession? A. The claimant mistakenly believed the property where he resides was his, due to an unclear property description in his title. B. The claimant paid all property taxes on the property while he resided there. C. The claimant resided on the property for 6 years before the actual owner attempted to have him evicted from the property. D. The property in question is part of federally owned parkland. Correct answer is D. The property in question is part of federally owned parkland. To qualify for adverse possession, the property cannot be owned by the federal or state government. The other elements required for adverse possession claims are that the non-permissive use is actual, open and notorious, payment of taxes, exclusive, hostile, against the interests of the owner, and continuous for 5 years or more. Question 21. The second installment of real property taxes becomes due on A. February 1st, B. June 1st, C. December 31st, D. January 1st. Correct answer is A. February 1st. The second installment is due on February 1st and is delinquent if the payment is not received by 5 p.m. or postmarked by April 10th. Question 22. When a real estate broker sells a land contract, he must arrange for the contract to be properly assigned and recorded in the county where the real property is located within how long after escrow is closed? A. 5 days. B. 10 days. C. 1 month. D. It is not the broker's responsibility to have the land contract recorded. Correct answer is D. It is not the broker's responsibility to have the land contract recorded. A land contract is an agreement between a seller and buyer in which the buyer obtains financing from the seller to purchase the property for an agreed-upon price and then repays the loan in installments. A broker who obtains a commission for a loan transaction such as a land contract must have the agreement recorded within 10 days of the close of escrow. Question 23. The instrument used to secure a loan on personal property is A. Collateral agreement. B. Pledge agreement. C. Trust deed. D. Security agreement. Correct answer is D. Security agreement. The security agreement is a document providing a lender with a security interest in a specified asset or property that is pledged as collateral. If the borrower defaults, the pledged collateral can be seized and sold. While a collateral agreement can be part of a loan agreement, it doesn't necessarily create a security interest. It might simply specify the collateral that will be used to secure the loan. A pledge agreement is typically used for creating a pledge, which involves transferring possession of personal property to the creditor until the loan is repaid. Trust deeds are primarily used for real estate loans, where the title is held by a trustee in case of default. They are not typically used for securing loans on personal property. Question 24. Generally, the biggest industrial finance loans are funded by A. Savings and loans. B. Commercial banks. C. Insurance companies. D. Fannie Mae. Correct answer is C. Insurance companies. Savings and loans, S&Ls, traditionally focus on residential mortgages and consumer loans. Commercial banks can be involved in industrial lending, but insurance companies often have a larger capacity for these large loans due to the nature of their business model. Fannie Mae is a government-sponsored enterprise, GSE, that deals primarily with residential mortgages. Insurance companies have large pools of capital from premiums paid by policyholders. They often seek investment opportunities for this capital, and big industrial loans can be an attractive option for them. These loans offer potentially high returns, but also come with higher risk compared to many other investment options. Insurance companies can manage this risk by carefully assessing the borrower's creditworthiness and structuring the loan terms appropriately. Question 25. They work directly with borrowers, set up real property appraisals, underwrite and service loans. They are A. Fannie Mae. B. Primary mortgage lenders. C. Investors in government securities. D. Secondary mortgage lenders. Correct answer is B. Primary mortgage lenders. Fannie Mae is a government-sponsored enterprise, GSE, that buys mortgages from lenders and packages them into mortgage-backed securities. Investors in government securities are entities that invest in government bonds and other debt instruments issued by governments. Secondary mortgage lenders buy existing mortgages from primary lenders. Fannie Mae, investors in government securities, secondary mortgage lenders don't typically work directly with borrowers, set up appraisals, or service loans. Primary mortgage lenders are the financial institutions that originate mortgages. They handle the entire process from initial contact with the borrower, application processing, underwriting, evaluating the loan risk, loan approval, and often servicing the loan, collecting monthly payments. They work directly with borrowers and ensure all the steps are completed for the loan to be funded. Question 26. The front-end ratio for a loan is determined by A. The amount of mortgage interest owed during the first 6 months of the loan. B. Calculating the percentage of monthly income necessary to meet monthly housing expenses. C. Calculating the percentage of monthly income necessary to meet monthly housing expenses minus any short-term debts. D. The introductory loan interest rate. Correct answer is B. Calculating the percentage of monthly income necessary to meet monthly housing expenses. The amount of mortgage interest owed during the first 6 months of the loan focuses only on a portion of the interest and doesn't represent the overall housing expense burden on the borrower. Calculating the percentage of monthly income necessary to meet monthly housing expenses minus any short-term debts is more like the debt-to-income ratio, DTI, which considers all debts, not just housing expenses. The introductory loan interest rate just influenced the initial payment amount. The front-end ratio helps lenders assess a borrower's ability to afford their monthly housing payment, including principal, interest, taxes, and insurance, PITI. It's expressed as a percentage of the borrower's gross monthly income. The front-end ratio is also known as the housing ratio. Question 27. To find the value of Greenacre, an appraiser looks at a comparable home in the same neighborhood that sold for $250,000 a year ago. During that year, property values for that neighborhood rose 8%. So, Greenacre is now worth A. $290,000, B. $300,000, C. $270,000, D. $350,000. Correct answer is C. $270,000. $250,000 by 8%, expressed as 0.08, equals $20,000. $250,000 plus $20,000 equals $270,000. In law, a Greenacre is a fictitious estate in land used to discuss the rights of different parties to a piece of real property. Law professors in common law jurisdictions often use Greenacres as placeholder names. Question 28. The most common type of lease agreement lasts for a specific period, such as month to month or year to year. This agreement is called A. Life estate, B. Periodic tenancy, C. Estate at sufferance, D. Tenancy at will. Correct answer is B. Periodic tenancy. A life estate grants someone the right to occupy a property for their lifetime or the lifetime of another designated person. An estate at sufferance, also known as tenancy at sufferance or holdover tenancy, is a legal term that describes a tenant who continues to occupy a rental property after their lease has expired. The tenant is also known as a holdover tenant. A tenancy at will is a lease agreement with no fixed term. It can be terminated by either landlord or tenant at any time, usually with proper notice. Periodic tenancy automatically renews for the same period, month to month, year to year, unless either party provides notice to terminate the lease before the end of the current period. This is the most common type of lease agreement for residential rentals. Question 29. Andy promises to paint Sandy's house if Sandy will promise to drive Andy and his dog to Canada. If Sandy makes that promise in return, it would qualify as A. Consideration, B. An option, C. A pledged promise, D. All of the above. Correct answer is a consideration. Consideration, an element of a binding contract, does not have to be in the form of money. It may consist of a promise to perform a desired act or a promise to refrain from doing an act. In a bilateral contract such as this one between Sandy and Andy's dog, an agreement by which both parties exchange mutual promises, each promise is regarded as sufficient consideration for the other. Question 30. A court would likely find fraud had been committed if A. An unintentional mistake by the seller persuades the buyer to purchase a property, B. The buyer purchases property based on the seller's lie, C. The seller's agent informs the buyer if he does not go ahead with the purchase, the agent will ruin the buyer's business, D. All of the above. Correct answer is B. The buyer purchases property based on the seller's lie. The unintentional use of false information by the broker in A is considered misrepresentation, not fraud. The agent's threat to the buyer in C is an example of duress. Question 31. During the loan term, the lender may ask the borrower to make regular payments towards the recurring costs. These payments are deposited into A. Impound account, B. Custodial account, C. Reserve account, D. Both A and C. Correct answer is D, both A and C. The payments are kept in an impound account, also called a reserve account. The funds in the account are used by the lender to pay recurring expenses such as taxes and insurance. Question 32. Brian, a potential buyer, offered to purchase the home of Oscar, the owner, sending a written offer to Oscar's listing broker. Oscar decided to accept the offer, while changing the amount of the good faith deposit from $10,000 to $15,000 by writing in the higher number on the offer form. He then communicated his acceptance of the offer by signing it and sending it back to the broker, who properly notified Brian, the buyer. The acceptance of the offer is A, binding upon Brian because Oscar only changed one of the terms, B, binding upon Oscar since he signed the offer, C, binding upon Brian, but for the original deposit amount, D, non-binding upon any of the parties. Correct answer is D, non-binding upon any of the parties. Once a party changes a term of the offer, it automatically terminates while a counter-offer is created. Brian's silence doesn't imply acceptance. Unless Brian explicitly agrees to the new deposit amount, his silence doesn't automatically bind him to the counter-offer. In this scenario, neither the original offer nor the counter-offer has been definitively accepted. Here's how the situation might unfold. Brian could choose to accept Oscar's counteroffer with the higher deposit amount. Brian could propose a new offer with a different deposit amount or other changes. The negotiation could continue until they reach a mutually agreeable offer, or both parties could walk away. It's important for both parties to clearly communicate their intentions to avoid any misunderstandings or disputes during the offer and acceptance stage of a real estate transaction. Question 33. By executing a power of attorney document, a party conveys legal authority to a representative designated to make property, financial and other legal decisions on the party's behalf. The party's representative is called A.N. A. Quasi-attorney, B. Special agent, C. Fiduciary, D. Attorney in fact. Correct answer is D. Attorney in fact. The power of attorney will terminate upon the incapacity of the party making the assignment, unless it contains a durability clause. An attorney in fact, also known as an agent, is someone who is legally authorized to act on behalf of another person in real estate transactions. The person who appoints the attorney in fact is called the principal. The attorney in fact doesn't need to be a lawyer, and can perform a wide range of personal and financial functions. Question 34. Every month for the last 5 years, a broker collects the rent for apartment units on behalf of the building's owner. On January 31st, the owner suddenly dies. The next day, when the agent makes his regular trip to collect the monthly rents, one of the apartment tenants refuses to pay the broker on the grounds that the owner's death had automatically revoked the existing agency between the owner and the broker. Is the tenant legally justified in withholding rent? A. Yes, the tenant is correct. B. No, the broker has the right to continue collecting the rent as long as he deposits the funds in an escrow account administered by the owner's heirs. C. No, the broker has the right to collect the rent until the owner's will is made public. D. A judge will need to decide the issue. Correct answer is a yes, the tenant is correct. An agency terminates upon the death of either party. Question 35. A broker can pay a portion of his commission to the buyer, if the broker A. informs the real estate commissioner, B. informs the seller, C. does not pay the seller more than half his total commission, D. it is illegal for the agent to pay any portion of his commission to the buyer. Correct answer is B. informs the seller. While there might be specific regulations depending on the jurisdiction, in most cases, a broker can share a portion of their commission with the buyer as long as they inform the seller and obtain the seller's consent. Transparency is crucial. The seller has the right to know how much commission is being paid and how it's being divided. The seller needs to agree to the commission split with the buyer. Question 36. A legal document that requires a borrower to pay a particular interest rate during a certain period of time is called a trust deed, B. bond, C. note, D. certificate of deposit. Correct answer is C. note. A trust deed is used instead of a mortgage to secure a loan on real property. It involves a third-party, trustee, holding the title until the loan is repaid. A bond is a debt security issued by governments or corporations, promising to repay a principal amount plus interest over a specific time. Certificate of deposit, CD, is a bank account that offers a fixed interest rate for a specific term. A note, short for promissory note, is a legal document that outlines the terms of a loan, including the principal amount, interest rate, repayment schedule, and borrower's obligations. Question 37. All of the following statements about an attorney in fact are true, except A. One who is legally authorized to act on someone else's behalf. B. A fiduciary. C. They must be an actual attorney. D. An agent. Correct answer is C. They must be an actual attorney. Any competent adult can be appointed as an attorney in fact, as long as they are not disqualified by the power of attorney document or state law. In order to be designated as someone's attorney in fact, the principal must sign a power of attorney form. Question 38. All of the following are required to be in writing, except A. Real estate sales contract. B. Listing agreement. C. Agency agreement. D. 6-month lease. Correct answer is D. 6-month lease. The statute of frauds require all these agreements to be in writing and signed, except the leasing agreement with a term of less than a year. Question 39. A homeowner renovates his home, doing all the work himself, but fails to pay the provider of his new sinks and piping. This plumbing supplier can file A against the owner. A. Writ of attachment. B. General lien. C. Straight note. D. Mechanics lien. Correct answer is D. Mechanics lien. A writ of attachment is a court order to seize a debtor's assets before a judgment is issued. It's a more extreme measure typically used in lawsuits. A general lien would encumber all of the homeowner's property, not just the specific property improved with the unpaid materials. A straight note is a promissory note, a written promise to repay a debt. While the supplier might have a note from the homeowner, filing a lien is a way to secure payment by attaching a legal claim to the property itself. Under the law, a mechanic is anyone who provides labor, services, or supplies to improve real property, like carpenters, electricians, roofers, and plumbers. A lien is a legal claim against real property. A mechanic's lien, then, is a legal hold against your property. It is recorded in the county recorder's office by individuals or entities who are owed money for their contributions to improving your property. Question 40. The body of laws created in 1952 by a national commission and the American Law Institute to help regularize the law of sales across the nation is called the A. Library of Sales Codes. B. Uniform Commercial Code, UCC. C. National Sales Standardization Protocol. D. None of the above. Correct answer is B. Uniform Commercial Code, UCC. Library of Sales Codes isn't the name of a specific legal code. National Sales Standardization Protocol. This sounds similar but isn't the official term by the National Commission and the American Law Institute. The UCC plays a crucial role in governing commercial transactions by providing a consistent legal framework across different states. It covers various aspects of commercial activities, including sale of goods, leases, secured transactions, using property as collateral for loans, negotiable instruments, checks, promissory notes, letter of credit. While each state can adopt its own version of the UCC, there's a high degree of consistency across these versions, promoting predictability and efficiency in interstate commerce. Question 41. Which of the following is not true about amortization? A. Over a period of time, the interest portion decreases as the loan balance decreases. B. Over a period of time, the interest portion increases as the loan balance decreases. C. Over a period of time, the amount applied to the principal increases. D. None of the above. Correct answer is B. Over a period of time, the interest portion increases as the loan balance decreases. A portion of the loan payment pays the loan's accruing interest, while the rest goes toward the principal. After a while, the portion going toward the principal will increase until the loan is paid. Question 42. California homestead law provides for the following forms of homestead exemption protecting against certain judgment creditors' attempts to force the sale of the home. A. Residential homestead exemption. B. Automatic homestead exemption. C. Declared homestead exemption. D. All of the above. Correct answer is D. All of the above. The residential homestead exemption, also called the automatic homestead exemption, does not require the recording of any document. The homeowner qualifies for the exemption based merely on residency. The declared homestead mandates the recording of a homestead declaration and provides more protection against judgments than the residential exemption. Question 43. An owner accepted an offer for the purchase of his home and an escrow was opened. Subsequently, the buyer discovered the owner had made misrepresentations regarding the home's accessibility for internet and phone service. There wasn't any. The contract to purchase thus becomes A. Invalid. B. Voidable by the owner. C. Voidable by the buyer. D. Binding on all parties, if the owner can show that he believed a cable company was going to make service available to all the homes in the neighborhood before escrow was due to close. Correct answer is C. Voidable by the buyer. A misrepresentation is an assertion not in accord with the truth. When a person enters a contract because of justifiable reliance on a misrepresentation about some important fact, the contract is voidable by the deceived party. In our scenario, even though the owner's misrepresentation was innocent rather than fraudulent, the owner honestly thought cable service was becoming available, the contract is still voidable by the buyer who can rescind it, or still go forward with the transaction if she wishes. Question 44. Which of the following facts should a seller's broker disclose when presenting an offer? A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. B. The Department of Real Estate changed its name to the Bureau of Real Estate. C. The prospective buyer is Asian. D. Both A and C. Correct answer is A. An offer that will likely be better is going to be presented by a cooperating broker within a few days. The broker has a duty to disclose material facts to his principal, and the fact that a better offer is set to be presented is definitely material to the owner. Question 45. An agent acting as a dual agent for both buyer and seller in a 1031 exchange does not disclose his dual agency to both parties. This failure to disclose will A. Provide either party with grounds to rescind the purchase agreement. B. Deny the agent the right to receive a commission. C. Subject the agent to discipline by the real estate commissioner. D. All of the above. Correct answer is D. All of the above. An agent in a 1031 exchange is required to obtain the knowledge and consent of both parties to act as dual agent. Failing to do so can result in any or all of the choices given. Question 46. The Howards, Bob and Donna, owned a real estate property as husband and wife. When Bob Howard died, his will provided that all his interests should go to his youngest child, Marie. Daughter Marie would A. Share the entire property with her two other siblings and the spouse, Mrs. Howard, with each of the four individuals inheriting a 25% interest. B. Inherit an undivided 1/2 interest in the property. C. Inherit nothing since the entire estate automatically goes to the spouse, Mrs. Howard. D. Have the amount of her interest decided by the probate court. Correct answer is B. Inherit an undivided 1/2 interest in the property. Spouses may will their 1/2 interest, according to the rules of community property. Daughter Marie would inherit all of her father's property interest, an undivided half share. Question 47. When the U.S. cost of living index is rising, it will likely be accompanied by A. Rising inflation. B. Decrease in the value of the dollar. C. Rising deflation. D. Both A and B. Correct answer is D. Both A and B. Deflation is the opposite of inflation, where the general price level of goods and services falls over time. U.S. cost of living index rising. This directly indicates inflation, which is the sustained increase in the general price level of goods and services in an economy over time. A rising cost of living index reflects that prices are going up. Inflation often leads to a decrease in the value, or purchasing power, of the dollar. As prices rise, each dollar you have can buy fewer goods and services. So, rising inflation and a decrease in the dollar's value typically go hand in hand. Question 48. This type of mortgage loan can be increased without revising its terms. A. Wraparound mortgage. B. Open-end mortgage. C. Closed-ended mortgage. D. Fixed-rate mortgage. Correct answer is B. Open-end mortgage. A wraparound mortgage combines a new loan with the seller's existing loan, but the borrower makes a single monthly payment that covers both loans. The total loan amount typically doesn't increase without refinancing. A closed-end mortgage has a fixed loan amount for the entire term. You cannot borrow additional funds without refinancing. A fixed-rate mortgage offers a constant interest rate throughout the loan term. While the interest rate remains stable, the loan amount itself cannot be increased without refinancing. An open-end mortgage allows the borrower to access additional funds throughout the loan term, up to a pre-established credit limit, without having to refinance the entire loan. This means the original terms, interest rate, maturity date, remain unchanged, but the loan amount increases. Question 49. Tenant Charles notifies owner Sam that Charles surrenders his lease to a unit in a commercial building. Sam has the legal right to do which of the following? A. Signal his acceptance of the surrender by changing the locks on the door. B. Enforce the lease and continue to pursue rent payments from the lessor. C. Both A and B. D. Neither A nor B. Correct answer is C. Both A and B. The surrender of a lease terminates the lease agreement and concludes the tenant-landlord relationship as long as the landlord completely agrees. Question 50. The following would probably result in the greatest increase in home buying. A. Higher interest rates. B. Lower interest rates. C. Greater supply of housing. D. Decreased supply of housing. Correct answer is B. Lower interest rates. When interest rates are lower, borrowing money to buy a home becomes cheaper. The monthly mortgage payment decreases, making homeownership more affordable for a larger pool of potential buyers. This typically leads to an increase in home buying activity. Question 51. Grown siblings can take title to property as A. Tenants in common. B. Community property. C. Joint tenants. D. Both A and C. Correct answer is D. Both A and C. Tenants in common, TIC, grown siblings can own property as tenants in common. In a TIC ownership, each sibling owns a specific, undivided share of the property. They can inherit, sell, or gift their share independently. Joint tenants, JT. This is another possibility for grown siblings. In a joint tenancy, siblings would typically own the property with equal rights of ownership, unless otherwise specified. There's also the concept of right of survivorship, which means that if one sibling passes away, their ownership interest automatically transfers to the remaining siblings. Community property, CP, is a legal ownership concept specific to marital estates. It applies to property acquired during the marriage. Question 52. If a veteran purchases a home under the Calvet program, the grant deed is executed under the name of the A. California Department of Veterans Affairs. B. The lender for the loan. C. The title company. D. The veteran. Correct answer is a California Department of Veterans Affairs. Calvet Sales employ a land sales contract with the California Department of Veterans Affairs as the seller, vendor. Question 53. A prospective borrower applies for a loan to buy a property in a poor neighborhood. Although the loan applicant has excellent credit scores and a steady income, and the property has excellent potential for renovation, the local lender turns down the loan app. The lender is probably A. Justified, because the property is in a disadvantaged neighborhood. B. In violation of the Rumford Act. C. In violation of the Holden Act. D. Likely to have its license revoked by the controller of the currency. Correct answer is C. In violation of the Holden Act. Under California's Holden Act, the lender must make lending decisions based on the worthiness of the borrower and the security property, not on the property being in a certain neighborhood. It is against public policy to refuse mortgage loans or to impose stricter loan terms due to neighborhood characteristics. Another state law, the Rumford Act, prohibits discrimination based on the applicant's race, color, religion, gender, sexual orientation, and other protected groups. Question 54. Which of the following kinds of deed carries no warranties of title? A. Quitclaim deed. B. Trust deed. C. Sheriff's deed. D. Both A and C. Correct answer is D. Both A and C. A quitclaim deed is used to correct a technical flaw in an earlier deed or clear a cloud on title. It is often referred to as a reformation deed. This kind of deed is used when the grantor is unsure of the validity of his title and does not want to provide warranties. A court-ordered sale of property is executed through a sheriff's deed, which also carries no warranties of title. Question 55. On a construction loan, the lender's last payment usually will not be made until A. The building is completed. B. After the expiration of the lien period. C. The close of escrow. D. It is listed by a broker. Correct answer is B. After the expiration of the lien period. For general contractors, mechanics liens must be filed within 60 days of the filing of a notice of completion and within 90 days if no notice is filed. Lenders like to wait until such lien rights have passed before releasing the final payment. Question 56. Homestead protection can be terminated in all the following ways, except A. If the homestead is sold. B. If a creditor brings a legal action against the homesteader in bankruptcy court. C. If the homesteader files a declaration of abandonment. D. If the homesteader files a declaration of homestead on another property. Correct answer is B. If a creditor brings a legal action against the homesteader in bankruptcy court. Selling the property removes your primary residence status, which is a key criterion for homestead protection. The homesteader files a declaration of abandonment. This is a legal document where the owner intentionally relinquishes their ownership rights and homestead protection of the property. Homestead protection typically applies to only one primary residence. Filing a homestead declaration on another property can be seen as an indication of abandoning the original homestead protection. However, bankruptcy court is an exception. Federal bankruptcy law limits the ability of creditors to seize a debtor's homestead exemption. The homestead exemption shields a certain amount of equity in the property from being used to satisfy creditors in a bankruptcy case. Question 57. A real estate agency would not terminate if A. The principal revokes the agency on his own accord. B. The property that is the subject of the agency is destroyed in a fire. C. The principal is killed. D. The principal fails to accept an offer brought to him by the agent within the allotted time period to decide, terminating the offer. Correct answer is D. The principal fails to accept an offer brought to him by the agent within the allotted time period to decide, terminating the offer. The principal has the right to terminate the agency relationship at any time, as long as they do so in accordance with the terms of the agency agreement, if one exists. If the property is destroyed, the agency is no longer possible as there's nothing left to sell or lease. An agency relationship is generally terminated by the death of the principal, because the agency is based on the personal relationship and capacity of the principal. The termination of an offer does not, in itself, terminate the agency between the principal and agent. The agent's obligation is typically to present offers to the principal. If the principal doesn't take action within the specified timeframe, usually outlined in the offer itself, the offer might expire. However, the agency agreement between the principal and the real estate agent would likely remain in effect unless terminated by one of the parties as mentioned above. Question 58. Which of the following is a kind of promissory note? A. Straight note. B. Fixed term note. C. Installment notes. D. Both A and C. Correct answer is D. Both A and C. The borrower signs a promissory note, or note, as it is sometimes referred to, when a loan is made. This note states that a certain amount of money is borrowed on a promise of repayment. The promissory note thus becomes an evidence of the debt. The borrower is referred to as a maker, and the lender is referred to as a payee. Question 59. Once a tenant has vacated leased premises, his security deposit should be returned by the landlord in A. 10 days, B. 21 days, C. 1 month, D. There is no deadline for returning the deposit. Correct answer is B. 21 days. Landlords are legally obligated to return security deposits within a reasonable timeframe, and specific deadlines in most states is 21 days. If the deposit, or portion of the deposit, is not returned, the landlord must send the ex-tenant a written explanation as to why. Question 60. All listings, deposit receipts, and trust account records must be retained by a real estate broker for A. 2 years, B. 5 years, C. 10 years, D. None of the above. Correct answer is D. None of the above. Most records dealing with real estate brokerage must be kept for 3 years, except those relating to mortgage loan or securities brokerage, which must be held onto for 4 years. Question 61. Real property built up alongside a river is acquired through A. Accession, B. Escheat, C. Grant deed, D. Quiet title action. Correct answer is A. Accession. Accession is an addition to property through human efforts or by natural forces. Real property that builds up alongside a riverbank refers to accession by a natural occurrence. While accession allows for addition by both human and natural forces, accretion is by natural forces only. Question 62. Which of these 4 terms does not fit with the others? A. Offer, B. Consideration, C. Deed, D. Acceptance. Correct answer is C. Deed. All but deed are elements of valid contract. Question 63. An easement created by use of property without the permission of the owner is called A. Prescriptive easement, B. Implied easement, C. Involuntary easement, D. Statutory easement. Correct answer is a prescriptive easement. An implied easement is created by implication of law based on the nature of the property and the presumed intent of the original grantor. The involuntary easement isn't commonly used in legal contexts. While an easement can restrict the property owner's use of their land, it's not necessarily involuntary. A statutory easement is created by a statute, not by use of the property. A prescriptive easement is a legal concept that allows someone to acquire an easement over another's property through continuous and uninterrupted use for a specific period of time, without the owner's permission. This required use period varies by state, but it typically spans several years. Question 64. A real estate licensee sells property to a young married couple but later learns they are both 17 years of age. This transaction could be described as A. Valid, B. Void, C. Voidable, D. Unenforceable. Correct answer is A. Valid. Married people under 18 years old are judged to be emancipated minors, and so are eligible to make a real estate transaction. Question 65. Which of these actions can be legally taken by a minor without prior approval of the court? A. Have their real property sold by a guardian, B. Provide a power of attorney sufficient to encumber their real property, C. Obtain real property via inheritance or gift, D. Both A and C. Correct answer is C. Obtain real property via inheritance or gift. Minors are generally not competent to manage or sell real property on their own. In most cases, court approval would be required for a guardian to sell a minor's real property. A power of attorney allows someone to designate another person to act on their behalf. Since minors are not considered legally competent to manage real estate, they typically cannot grant a power of attorney to encumber, put a lien on, their real property. Inheritance and gift laws are designed to allow the transfer of property wealth across generations. While a minor might not be able to manage the property themselves, A guardian can be appointed to oversee its care and ensure it benefits the minor. Question 66. When the title to property is given to the lender as a guarantee against the repayment of a loan, but the borrower keeps physical possession of the property, it is called A. a promissory note, B. a land contract, C. hypothecation, D. a trust deed. Correct answer is C. hypothecation. A promissory note is a written promise to repay a loan, but it doesn't involve transferring title to property. A land contract is an agreement to sell real estate in the future, with ownership typically transferring upon full payment. It doesn't necessarily involve using the property as security for a loan. A trust deed is similar to a mortgage, where title is transferred to a trustee as security for the loan. However, in some states, a trust deed might involve the lender taking possession of the property upon default, which isn't the case in hypothecation. Hypothecation is a legal concept where a borrower pledges an asset, like real estate, as collateral for a loan but retains physical possession of the asset. The lender gains a security interest in the property, meaning they can seize and sell it if the borrower defaults on the loan. Question 67. Josh is a board member of 2 corporations which both make and market motor oil. He does not disclose this dual membership to anyone. If Josh is subsequently sued for breaching his fiduciary duties, the court would likely base its ruling on the A. antitrust rules, B. duty of loyalty, C. duty of fair dealing, D. duty of implied impartiality. Correct answer is B. duty of loyalty. Under the duty of loyalty, a corporate director should behave in a manner demonstrating his complete dedication to the company which employs him. Whether or not Josh is sharing information between the 2 competing companies, his simultaneous membership on the boards of both sets up the appearance of impropriety that violates his fiduciary responsibilities. Question 68. For the purposes of appraisal, the key element of value falls under 2 categories: value in use and A. value in land, B. value index, C. value in exchange, D. value added tax. Correct answer is C. value in exchange. Value in exchange is how an average person would objectively value a property, also called market value. Value in use is the subjective value placed on a property by its owner, which includes the emotional aspects of being familiar with the property. Question 69. A lease that a lessee subleases to another party who is the actual user of the property is called an A. operating lease, B. assignment, C. estate for years, D. novation. Correct answer is a operating lease. An operating lease is commonly used to acquire equipment on a relatively short-term basis. Question 70. Which of the following best describes a trust as a form of property ownership? A. Title is held by the trustee on the beneficiary's behalf. B. Title remains with the original owner who releases it to the beneficiary on a certain date. C. Title is entrusted to a beneficiary if the probate court agrees. D. None of the above. Correct answer is a title is held by the trustee on the beneficiary's behalf. A trust is a legal arrangement in which a person, called a grantor, establishes a trust into which assets are transferred for a person, called the trustee, to control and manage for the benefit of the beneficiary. The grantor no longer holds legal title to the property, it is held by the trustee. The grantor can also sometimes be named the trustee, depending on the type of trust. Question 71. If a real property title that is encumbered by a trust deed is transferred through a sale, it is necessary to A. have the grantor provide the delivery of the deed, B. repay the trust deed balance in full, C. attain the permission of the lender, D. real property encumbered by a trust deed cannot be transferred. Correct answer is A. have the grantor provide the delivery of the deed. Even if a property is encumbered, it may still be conveyed. This is usually accomplished with a grant deed. Question 72. An easement appurtenant exists between 2 separately owned parcels of property. Bart owns the dominant tenements and Dave owns the servient tenement. If Bart sells his parcel to someone else, then A. Dave, the owner of the servient tenement, automatically assumes the rights of the dominant tenement. B. The new owner of Bart's property assumes the rights of the dominant tenement. C. The easement lapses with the sale of one of the properties. D. None of the above. Correct answer is B. The new owner of Bart's property assumes the rights of the dominant tenement. A servient tenement is a piece of land that is subject to an easement, which is a right or privilege that the owner of one parcel of real property has concerning another parcel of an estate. The owner of the parcel that benefits from the easement is called the dominant estate or dominant tenement, and the parcel that is subject to the easement is called the servient tenement. When Bart sells his property, dominant tenement, the easement appurtenant automatically transfers to the new owner. They inherit the rights granted by the easement, such as access or use of Dave's property, servient tenement. If it had instead been an easement in gross belonging to Bart, or personal easement, the benefit would indeed have ended with the sale of Bart's property to a new owner. Question 73. Real estate advertising is governed by rules created by all of the following, except A. The California Advertising Board, B. The Truth in Lending Act, TILA, C. Real estate law, D. Regulations of the Real Estate Commissioner. Correct answer is A. The California Advertising Board. California Advertising Board is not directly involved in regulating real estate advertising. It focuses on general advertising standards and licensing for businesses engaged in advertising activities. Real estate advertising is subject to a combination of federal and state regulations. 1. Real estate professionals must comply with the specific advertising rules established by their state real estate commission or licensing board as real estate law or regulations of the Real Estate Commissioner. 2. Additionally, federal laws like TILA might impose disclosure requirements for certain aspects of real estate advertising, particularly when it involves financing options. Question 74. Under the California Civil Code, if a broker was showing real property to a prospective purchaser where someone had died 5 years earlier, that fact would be considered A. A material defect required to be disclosed, B. Not required to be disclosed. Circa a material defect but only required to be disclosed if the death was non-accidental, D. Any of the above, at the discretion of the broker. Correct answer is B. Not required to be disclosed. A death on a property is a material fact that must be disclosed but only if the death occurred within 3 years of the date of the offer to purchase or rent. Question 75. The Uniform Commercial Code, UCC, requires a notice to creditors of a business that is making a bulk sale must be published at least before the sale is transacted. A. 1 day, B. 12 days, C. 1 month, D. 3 months. Correct answer is B. 12 days. Enacted to ensure that creditors of a business are made aware the business may be trying to dispose of its inventory, notice is required to be published at least once, at least 12 days prior to the sale. Question 76. In an option agreement, consideration refers to the A. Appraisal of the option property, B. Optionee's promise to try to purchase the option property, C. Something of value conveyed by the optionee to the optioner for the right to purchase the option property, D. Past services rendered by the optionee to the optioner. Correct answer is C. Something of value conveyed by the optionee to the optioner for the right to purchase the option property. The person granting the option is called the optioner. The one obtaining the benefit of the option is the optionee. Consideration is an item of value, not necessarily money, provided by the optionee to secure the optioner's promise not to convey the option property to anyone else during a set time period. An option contract, or any contract, for that matter, can never be based upon consideration provided before the promise was made. Question 77. Alleged violations of the real estate law are prosecuted by the A. FBI, B. California Secretary of State, C. Local district attorneys, D. Both A and B. Correct answer is C. Local district attorneys. Such offenses are prosecuted on a local level. Question 78. A will that is dated, written, and signed in the testator's own handwriting is A. A holographic will, B. Non-binding, C. A parole will, D. Admissible if a majority of the decedent's immediate family agrees. Correct answer is A. A holographic will. A holographic will is a handwritten document that expresses a person's wishes for their assets after death, without the need for witnesses or a lawyer. The testator, or person who creates the will, writes it in their own handwriting and signs it. Holographic wills are an alternative to wills produced by a lawyer, and are less commonly used than a standard living will. Question 79. The following are base and meridian lines in California, except A. Humboldt, B. Mount Shasta, C. Mount Diablo, D. San Bernardino. Correct answer is B. Mount Shasta. The U.S. Public Land Survey System, PLSS, also known as the Rectangular Survey System, is a method for dividing land into grid-shaped townships and sections for sale and settlement. The PLSS was established in 1785 by the Second Continental Congress to survey land ceded to the United States by the Treaty of Paris in 1783. Thomas Jefferson first proposed the system as a way to divide up the original public domain lands. Question 80. Which loans are most similar to each other? A. Interim loan, takeout loan, B. Interim loan, construction loan, C. Construction loan, standby loan, D. None of the above loans are similar. Correct answer is B. Interim loan, construction loan. Interim loans are often used for projects with multiple phases, where funding is dispersed in stages as construction progresses and milestones are met. Construction loans typically cover the entire project cost up front and are paid back with interest over a set term after construction is complete. They share these similarities. Used for financing construction, short-term financing, involve progress monitoring or milestones. A takeout loan is a permanent financing option used to repay a shorter-term loan, like a construction loan. They are not directly involved in funding construction itself. A standby loan is a loan commitment that guarantees financing if certain conditions are met. It's not directly used for construction funding but provides a safety net for the borrower. Question 81. Agency relationships, like a listing, may be terminated in all of the following ways, except A. If the property with which the agency is concerned is destroyed, B. Mutual termination agreed upon by both the seller and agent, C. Resignation of the agency by the broker, D. Revocation by the principal if the agent owns an interest in the agency's subject. Correct answer is D. Revocation by the principal if the agent owns an interest in the agency's subject. If an agent has an interest in the agency's subject matter, say, if a broker owns a third of the property, the principal cannot revoke the agency. Question 82. Building standards in California are set statutorily by the Housing Act. Regarding the building regulations in the state's unincorporated areas, the Housing Act A. applies, along with the County Building Code, B. does not apply, since it is in effect only for urban public housing, C. does not apply, since it is in effect only for incorporated areas, D. does apply, if the County Building Code does not. Correct answer is A. applies, along with the County Building Code. The California Housing Act establishes a framework for building standards throughout the state. Unincorporated areas are not exempt from these standards. However, there's an additional layer to consider. County building codes. Most counties in California have their own building codes that comply with, and may even exceed, the minimum requirements set by the Housing Act. Therefore, in unincorporated areas, both the California Housing Act and the specific county building code would apply to building regulations. A project would need to comply with both sets of standards to be approved. Question 83. An accidental death occurred on a property. 4 years later, is there a requirement for the broker showing the property to a potential buyer to disclose the death? A. Yes. B. Yes, but only if the buyer specifically asks about it. C. No, such disclosure might hurt the chances of making a sale. D. No, it is not a material fact. Correct answer is B. Yes. but only if the buyer specifically asks about it. California law states that death on a property doesn't have to be disclosed if it occurred more than 3 years prior to the sale unless a buyer asks. Many brokerage firms have supplemental disclosure forms that specifically mention death on a property. Question 84. The concept of the loan-to-value ratio, LTV, describes which of the following? A. Loan value to book value. B. Appraised value to market value. C. Loan value to sale value. D. Loan value to appraised value. Correct answer is D. Loan value to appraised value. The loan-to-value ratio, LTV, is a financial metric used by lenders to assess the risk associated with a loan secured by real estate. It compares the amount of money borrowed, loan value, to the appraised value of the property. Question 85. Mutual mortgage insurance is included in the issuance of which of the following types of loan? A. FHA loan. B. Conventional loan. C. VA loan. D. Jumbo loan. Correct answer is A. FHA loan. FHA loan, Federal Housing Administration loan, which is government-backed loans, often insured by private mortgage insurance, PMI, companies through the Federal Housing Administration, FHA, program. Mutual mortgage insurance, MMI, is a specific type of private mortgage insurance used for FHA loans. It provides lenders with a financial guarantee if the borrower defaults on the loan. Question 86. The number of feet on each side of a square acre of land would round off to A. 100 feet, B. 204 feet, C. 209 feet, D. 1,000 feet. Correct answer is C. 209 feet. 1 acre is equal to 43,560 square feet. The side length is the square root of 43,560 square feet equal 209 feet. Question 87. Failing to perform a duty that was promised in a contract amounts to A. Cancellation of the contract. B. Novation of the contract. C. Breach of the contract. D. Rescission of the contract. Correct answer is C. Breach of the contract. A breach occurs when a party fails to perform all or part of the obligations required by the contract. In that case, the non-breaching party can obtain legal relief. Question 88. Joan Simpson and Mary Mass, two single women, plan to take title to a home in such a way that each one will own a half interest with right of survivorship. The granting clause will state: A. Joan Simpson, a single woman, and Mary Mass, a single woman, co-tenants. B. Joan Simpson, a single woman, and Mary Mass, a single woman, each with an undivided one-half interest as tenants in common. C. Joan Simpson, a single woman, and Mary Mass, a single woman, as joint tenants. D. Simpson and Mass, joint proprietors. Correct answer is C. Joan Simpson, a single woman, and Mary Mass, a single woman, as joint tenants. Joint proprietors isn't commonly used in legal contexts for real property ownership. Tenants in common grants each woman a half interest, but it doesn't include the right of survivorship. If one owner dies, their interest would pass according to their will or intestacy laws. Co-tenants is a general term for people who own property together. It doesn't specify the type of ownership, which is crucial in this case. The right of survivorship is a legal principle that allows surviving owners to automatically inherit the deceased owner's share of property or assets. It's primarily associated with joint property ownership, such as joint tenancy and tenancy by the entirety. So, joint tenants is the most accurate and legally recognized way to achieve what Joan and Mary intend. By choosing joint tenants, Joan and Mary ensure that if one of them dies, the ownership of the entire property automatically transfers to the surviving owner. This avoids the need for probate for the deceased owner's interest in the property. Question 89. Creating a joint tenancy requires the four unities, but for a tenancy in common, the sole requirement is A. Interest, B. Possession, C. Time, D. Title. Correct answer is B. Possession. For a tenancy in common, the sole requirement is not one of the traditional four unities. joint tenancy are required the 4 unities to be met. The 4 unities of a joint tenancy are: 1. Unity of possession, each joint tenant has the right to possess the entire property. 2. Unity of interest, each joint tenant owns an equal and undivided interest in the property. 3. Unity of time, all joint tenants acquire their ownership interest at the same time. Unity of title, the ownership interest originates from the same document. The main difference between a joint tenancy and a tenancy in common lies in the presence of the right of survivorship. In a joint tenancy, if one owner dies, their interest automatically passes to the surviving joint tenants. In a tenancy in common, the deceased owner's interest will be passes according to their will or intestacy laws. Question 90. All of the following factors will affect the amount of a VA loan to a veteran, except A. Veteran's income, B. Veteran's intent to occupy the home, C. Appraised value of the property, D. Maximum loan amount imposed by the VA. Correct answer is D. Maximum loan amount imposed by the VA. The VA does not set a maximum loan limit on its guaranteed loans. While there are limits on the amount a qualified veteran may be able to borrow without making a down payment, these limits vary by county since the value of a house depends on its location. Question 91. The southwest quarter of a section contains A. 320 acres, B. 160 acres, C. 640 acres, D. Sections cannot be divided into quarters. Correct answer is B. 160 acres. The United States Public Land Survey System, PLSS, divides land into 6-mile square townships or 36 square mile. Townships are subdivided into 36 1-mile square sections. Sections are typically divided into quarters, X, NW 1 quarter, and sometimes halves, X, W 1 half, which are then divided again into quarters, X, NW 1 quarter of NW 1 quarter. A section is roughly 1 square mile, or 640 acres. Therefore, the southwest quarter, SW 1 quarter, of a section would be 1 quarter of 640 acres divide to 4 equal 160 acres. Question 92. A real estate salesperson employed by a broker sold a property listed by a different broker. In this situation, the salesperson can be paid his commission by A. The salesperson's employing broker only, B. Either the salesperson's employing broker or the listing broker, C. The listing broker, with the approval of the salesperson's employing broker, D. The listing broker, if he holds the commission for the salesperson in the broker's trust account. Correct answer is A. The salesperson's employing broker only. Salespersons can only be paid compensation by their employing broker, according to the real estate law. Question 93. Which of the following is not required in order to create an agency relationship? A. An agreement by the parties to create an agency relationship, B. An agreement to pay commission, circa a duty of loyalty by the agent to the principal, D. A legally competent principal. Correct answer is B. An agreement to pay commission. The key elements of an agency relationship are the consent of the parties, the agent acting on behalf of the principal, and the duty of loyalty owed by the agent. While commission is a common form of compensation for agents, especially in sales situations, it's not always a requirement for an agency relationship to exist. An agent could agree to act for the principal for free or in exchange for something other than a commission. Question 94. The space under the subfloor of a building designed to afford access to wiring and plumbing is called the A. Access panel, B. Crawl space, C. Cellar, D. Foundation. Correct answer is B. Crawl space. Although it does in fact offer access to wiring and plumbing, the correct term is crawl space. Question 95. Which of the following kinds of lien has the highest priority? A. Deed, B. Mechanic's lien, C. State tax lien, D. The lien earliest recorded. Correct answer is C. State tax lien. Tax and tax assessment liens are superior in priority against all other liens. Question 96. Which factors does an appraiser take into account when appraising an income-generating property? A. Present worth of future benefits. B. Degree of demand for a similar property. C. Neighborhood's unemployment rate. D. Either A or C. Correct answer is a present worth of future benefits. The value for an income property is decided by the present worth of future benefits to be generated during the property's remaining economic life. The present value of future benefits is important when dealing with lump sum settlements. The concept of present value means that a lump sum settlement today is worth more than it will at some time in the future. The process of adjusting for that is to discount future benefits to their present value. Question 97. The Los Angeles Dodgers signed Brock Ramon, a 17-year-old player, to a one-year contract worth $3 million. Because Ramon is a minor, he lacks the legal capacity to enter into a contract. Therefore, the contract is A. Void. B. Voidable. C. Valid. D. Unenforceable by either party. Correct answer is B. Voidable. In the United States, the legal age to enter into contracts is typically 18. Since Brock Ramon is 17, he is considered a minor and lacks the legal capacity to form a binding contract. Due to Ramon's lack of legal capacity, the contract between him and the Los Angeles Dodgers is considered void. This means the contract has no legal effect from the beginning. In some cases, there might be exceptions for certain types of contracts involving minors, but these typically require specific conditions or parental approval. Question 98. In order to avoid being taxed on income, a real estate investment trust, REIT, must distribute at least how much income to shareholders? A1, B, 0.9.C, 0.5.D. Such a distribution of income to be exempt from taxes is not permissible. Correct answer is B. 0.9. Shares in a REIT must be transferable and held by a minimum of 100 persons. A REIT must distribute at least 90% of its taxable income to shareholders annually in order to qualify for the tax exemption. This distribution is considered a dividend for shareholders and is taxed accordingly at their individual income tax rates. Question 99. Under the concept of hypothecation, a borrower maintains his status as legal owner of the property and retains his right of possession, while the lender holds A. Naked title. B. Equitable title. C. Bare title. D. All of the above. Correct answer is D. All of the above. Bare title and naked title are the same terms as equitable title, meaning the lender has a security interest in the collateral property. That interest will become a legal title if the borrower defaults or will end when the loan is fully repaid. Question 100. Which of these provides a taxation benefit related to the ownership of income-generating real property? A. Interest deduction. B. Appreciation deduction. C. Treatment of capital gains. D. All of the above. Correct answer is D. All of the above. Income-generating real property can offer several tax benefits, including 1. Interest deduction. Mortgage interest paid on a loan used to purchase or improve the property can be deducted from taxable income, reducing your overall tax burden. Treatment of capital gains. When you sell the property for a profit, capital gain, the tax rate on that gain might be lower than the ordinary income tax rate. There are specific holding periods and other qualifications to qualify for the lower capital gains tax rate. Depreciation deduction. The cost of the property, excluding the land, can be depreciated over a set period, allowing you to deduct a portion of that cost from your taxes each year. This reduces your taxable income even though you haven't necessarily sold the asset. These tax benefits can significantly reduce the overall tax liability associated with owning income-generating real estate. It's important to consult with a tax advisor to understand how these benefits apply to your specific situation. Note that the deduction of interest and favorable treatment of capital gains apply to all real properties, not just income-generating ones. Question 101. Escrow services are normally provided by title companies in A. Northern California. B. Southern California. C. Los Angeles County only. D. Title companies are not authorized to serve as escrow agents. Correct answer is A. Northern California. In Northern California, title companies are generally the escrow agents. In Southern California, independent escrow agents normally close most transactions. Many institutional lenders have their own escrow departments. Question 102. Who is entitled to the commission when a property is not listed at the time of the offer and has been shown to a buyer by more than one broker? A. The broker who is the procuring cause. B. Whoever listed the property prior to the sale. C. No one. D. All brokers who showed the property. Correct answer is A. The broker who is the procuring cause. The agent who writes an accepted offer is known as its procuring cause. Question 103. Private property that has been confiscated by the government for non-payment of taxes can be sold at public auction by the county tax authorities. A. Upon public notification of the impending sale. B. Upon public notification of the impending sale and mailing the notice to the property owner in arrears. C. Without notice. D. After posting a "for sale" sign on the property. Correct answer is B. Upon public notification of the impending sale and mailing the notice to the property owner in arrears. By law, the tax collector must complete both steps before the public sale: public notice, customarily done by publishing in the newspaper, and mailing the notice to the property owner who has failed to pay his taxes. Question 104. The safety clause in most exclusive listing agreements entitles the broker to a commission if the property is sold even after the listing term expires, provided the A. broker used his best efforts to procure a buyer during the listing term. B. broker had shown property to at least 5 potential buyers during the listing term. C. broker had negotiated with the eventual purchaser during the listing term. D. all of the above. Correct answer is C. broker had negotiated with the eventual purchaser during the listing term. The purpose of this clause is to protect the broker from parties who try to avoid paying the commission by waiting for the listing term to expire, and then making the purchase deal. Question 105. The following would be factors affecting economic obsolescence in a particular area, except A. zoning changes. B. oversupply of properties. C. inadequate number of electrical outlets in a home. D. recession. Correct answer is C. inadequate number of electrical outlets in a home. Economic obsolescence refers to a decrease in the value of a property due to external economic factors beyond the owner's control. The other answers relate to economic obsolescence, factors stemming from beyond the property. Question 106. One of the key elements of determining the value of a property is demand. But for demand to exist, it must be accompanied by A. professional appraisal. B. purchasing power. C. financing. D. staging. Correct answer is B. purchasing power. Demand is related to the number of those wanting the property. However, without the power to purchase a property, demand will have a weak effect on value. Question 107. Which of the following statements regarding an offer to purchase real property is correct? A. The offer must be in writing, but the acceptance does not. B. The acceptance must be in writing, but the offer does not. C. Neither the offer and acceptance need to be in writing, unless the property price exceeds $1 million. D. The offer and acceptance must both be in writing. Correct answer is D. The offer and acceptance must both be in writing. The statute of frauds requires both offer and acceptance to be in writing. Question 108. An unlawful detainer action can be commenced by a landlord against a tenant when A. the tenant fails to leave upon the expiration of his lease. B. the property is sold. C. there is a month-to-month lease, and the tenant does not move out after a 30-day, 60-day or 90-day notice to quit. D. all of the above. Correct answer is D. all of the above. An unlawful detainer action is a mechanism for landlords to regain possession of their property when a tenant is no longer legally entitled to remain there. The reasons listed in options A, B, and C are all valid grounds for an unlawful detainer action. Other times an unlawful detainer action can be started include when the tenant does not pay rent and fails to move out after receiving a 3-day notice, or the tenant similarly does not leave after getting a 3-day notice for committing an illegal act. Question 109. A real property seller can recover damages from a real estate broker if the broker A. acts in excess of his authority conveyed by the seller, B. makes a representation to the buyer authorized by the seller, C. discloses a material fact to the buyer regarding the intended use of the property, D. provides revised escrow instructions to the property's escrow agent. Correct answer is A. acts in excess of his authority conveyed by the seller. The broker would be liable for damages suffered by the seller for actions beyond the scope of his authority to his principal. The other actions are authorized. In fact, by law the broker must disclose to the buyer any material facts which affect the value, desirability and intended use of the property. Question 110. The State Attorney General's office would be legally required to become involved in which of the following cases? A. A real estate license applicant is accused of cheating on the licensing exam. B. A real estate developer is suspected of falsifying subdivision reports. Circa, a real estate broker whose license has been suspended sues to have the real estate commissioner's decision overturned. D. All of the above. Correct answer is D. All of the above. As the legal counsel for the Office of the Real Estate Commissioner, the State Attorney General would represent the Commissioner's interests in all of those scenarios. Question 111. Which of the following is a recurring cost? A. Appraisal fee. B. Title insurance. C. Pest control. D. Recording fee. Correct answer is C. Pest control. Recurring costs are those incurred in escrow that will recur after taking possession of the property, like pest control or property taxes. Question 112. The cost approach in appraisal relies on the following methods. A. Quantity survey method. B. Square foot method. C. Unit in place method. D. All of the above. Correct answer is D. All of the above. Quantity survey method involves breaking down the property into its component parts, materials, labor, overhead, and estimating the cost to rebuild it from scratch. Square foot method uses the cost per square foot to rebuild comparable properties to estimate the replacement cost of the subject property. Unit in place method assigns a cost per unit, e.g., per square foot of roof, per linear foot of plumbing, to various components of the property to estimate the replacement cost. Question 113. Prepaid rental listing agents are mandated to do the following, except A. Return the client fee if no referrals are submitted within 5 days of the agreement's execution. B. Provide a contract and receipt for every potential tenant, promising the return of their fee if certain circumstances are met. C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. D. Refund any funds over $25 if a rental is not procured. Correct answer is C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. A prepaid rental listing agent is required to keep records available for the Real Estate Commissioner's inspection at any time. Agents should be prepared to submit quarterly reports for principals regarding how the funds are used. Question 114. In order to authorize a conventional loan, many lenders require an applicant to have A. Financing assistance from a friend or a relative for a down payment. B. 2 months or more of mortgage payments in reserve. Circa, a steady job with the possibility of advancement. D. 3 or more previously paid in full mortgage loans. Correct answer is B. 2 months or more of mortgage payments in reserve. Lenders refer to the money which is still available to a borrower after making a home purchase as reserves. Borrowers with a higher amount of reserves are viewed as lower risks. 2 months of payments is considered the minimum amount of reserves needed, with the funds usually in the form of bank accounts, stocks, IRAs, etc. Question 115. Blind ads are A. Set up so consumers who respond believe they will be speaking to the seller, only to be connected instead to the agent posting the ad. B. Designed to be accessible to sightless individuals. C. Illegal. D. Both A and C. Correct answer is D. Both A and C. According to state law, a real estate ad must include the name of a broker and her telephone number, or it will be considered a blind ad, which is illegal. Question 116. The authority to investigate non-licensees believed to be performing real estate activities for which a license is required is held by the A. Police, B. District Attorney, C. Real Estate Commissioner, D. State Legislature. A. Police, B. District Attorney, C. Real Estate Commissioner, D. State Legislature. Correct answer is C. Real Estate Commissioner. The Real Estate Commissioner implements and enforces the provisions of the real estate law to provide protection to the members of the public dealing with real estate licensees. Question 117. Ronald presented an offer to Joan to purchase her house, with the provision that Joan respond within a week of getting the offer. Joan was considering two other offers to buy her house, but ultimately decided to accept Ronald's offer. 9 days after she received it, Joan asked her broker to communicate her acceptance of Ronald's offer to him. In this situation, A. Ronald is obligated to go ahead with the purchase, B. Ronald is under no obligation to go ahead with the purchase because Joan did not personally tender her acceptance to Ronald. C. Ronald is obligated to present a counter-offer that provides another opportunity for Joan to accept it in a timely manner. D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. Correct answer is D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. The meeting of the minds, that is a necessary element of a binding contract, did not occur when Joan failed to meet the window of acceptance specified by Ronald. Question 118. Types of real estate financing include the following: A. Assumptive, B. Equity, C. Debt, D. Both B and C. Correct answer is D. Both B and C. Equity funds refers to the owner's own money invested in the property. Debt funding originates with third parties, mostly from financial institutions. Question 119. When a real estate agent acts exclusively as a buyer's agent, he can do all of the following except: A. Present offers directly to the seller, B. Present offers to the seller and seller's agent, C. Withhold confidential information about the buyer from the seller, D. Act as an exclusive agent of the seller. Correct answer is D. Act as an exclusive agent of the seller. When the licensee is the exclusive agent for the buyer, he may not be the exclusive agent for the seller. Question 120. Which of the following actions by a broker would violate the rules regarding trust funds? A. Cashing a deposit check after acceptance of an offer at the seller's direction, B. Keeping a deposit check uncashed after acceptance of an offer at the seller's direction, C. Keeping a deposit check uncashed by their own decision, D. Keeping a deposit check uncashed before acceptance of an offer at the direction of the buyer. Correct answer is C. Keeping a deposit check uncashed by their own decision. Only principal parties can decide the proper handling of a deposit check. Question 121. Among the following factors, the most significant one affecting home value is: A. Quality of workmanship, B. Buyer demand, C. Square footage, D. Ratings for nearby schools. Correct answer is B. Buyer demand. While all the factors can influence home value, the most significant one is likely buyer demand. Home values are determined by what buyers are willing to pay in the current market. Even a well-built home with great school ratings might not fetch a high price if there's a lack of buyer interest in the area. Other factors can influence demand. Square footage, quality of workmanship, and school ratings can all play a role in attracting buyers. However, they are all somewhat subjective and influence desirability, which feeds into overall demand. Question 122. The recording of a lease will generally be performed by the A. Lessor, B. Lessee, C. County assessor, D. Life estate holder. Correct answer is B. Lessee. The lessee, the party who is the recipient of an estate for years, benefits the most from recording his interest and so is likely to be the one to do it. Question 123. To record a lease, there must be an acknowledgement of the document by the witnessed by an appropriate official. A. Lessee. B. Lessor. C. Notary. D. Realtor. Correct answer is B. Lessor. A requirement of recording is that a document must be acknowledged by the party transferring an interest in real property. For the transfer of a lease, that would be the lessor. Question 124. A real estate broker must retain copies of her listings, deposit records and receipts going back at least A. 1 year, B. 3 years, C. 5 years, D. The law doesn't specify years, just states records should be preserved for a good amount of time. Correct answer is B. 3 years. Most real estate brokerage records must be preserved for at least 3 years, while brokers' documents from their mortgage loan and securities business saved for at least 4. Question 125. Regarding a land contract, during the period in which the vendee, purchaser, is still making installment payments and title has not yet been transferred, the vendor, owner, may A. Encumber the property with a mortgage after getting permission from the vendee, B. Encumber the property with a mortgage without getting permission from the vendee. C. May not encumber the property with a mortgage under any circumstances. D. None of the above. Correct answer is B. Encumber the property with a mortgage without getting permission from the vendee. While the vendor still retains legal title, he is free to encumber or transfer the property without the vendee's consent. However, any mortgage liens must be paid off by the vendor before the deed is delivered to the vendee. Question 126. A landlord and lessee agree on terms of a 2-year lease for an apartment rental. The landlord signs the lease and sends it to the lessee, who receives it, moves into the apartment, sends the landlord 3 months' rents, but never sign the lease. Upon the completion of 3 months, the tenant decides to disregard the terms of the lease and move out. Given this scenario, a court will likely decide that A. The tenant is bound by the lease because he moved in and paid rent in advance. B. Since the tenant never signed the lease, he is not bound by it and can move out when he pleases. C. The tenant is bound by the lease because only a lessor, the landlord, need sign a lease. D. None of the above. Correct answer is A. The tenant is bound by the lease because he moved in and paid rent in advance. If a lessee either takes possession or pays rent in advance, he does not have to sign a lease to be bound by its terms. If assignment is not specifically prohibited in the terms, though, the tenant can find someone to take over the rest of the lease. Question 127. The term fiduciary does not apply to the following relationships between parties. A. Listing broker to seller. B. Truster to beneficiary. C. Attorney to client. D. Agent to principal. Correct answer is B. Truster to beneficiary. Fiduciary is an agency relationship. Truster to beneficiary is like borrower to lender, not a fiduciary relationship. Question 128. The buyer's good faith deposit for the sale of 1 to 4 unit, owner-occupied residential property can be used for liquidated damages, but only if A. The total amount being forfeited is not more than 3% of the purchase price. B. The contract was recorded. C. The contract contains a liquidated damage provision in large type separately signed and initialed by both parties. D. Both A and C. Correct answer is D. Both A and C. For a good faith deposit, GFD, to be used for liquidated damages in the sale of a 1 to 4 unit, owner-occupied residential property in California, 2 conditions must be met. 1. The amount forfeited cannot exceed 3% of the total purchase price of the property. This limitation protects the buyer from excessive penalties. 2. Liquidated damages clause with specific formatting. The purchase contract must contain a liquidated damages provision that is in large type. This ensures clarity and avoids any claims that the buyer missed the provision due to small print. And separately signed and initialed by both parties. This demonstrates that both parties were aware of the liquidated damages clause and agreed to its terms. Question 129. If a plaintiff wins a lawsuit based on the 1968 Civil Rights Act, the following remedies against the defendants are available, except a. Money damages for plaintiff's pain and suffering, b. Suspension or revocation of the license of the real estate agent whose unlawful actions led to the lawsuit, c. Money damages covering plaintiff's attorney fees, d. Punitive damages designed to discourage unlawful actions from recurring. Correct answer is B. Suspension or revocation of the license of the real estate agent whose unlawful actions led to the lawsuit. The 1968 Civil Rights Act, also known as the Fair Housing Act, prohibits discrimination in the sale, rental, and financing of housing based on several factors including race, religion, national origin, sex, and familial status. The federal courts where lawsuits are filed based on the Federal Civil Rights Act have no jurisdiction over real estate licensing in California. The power to suspend or revoke agent licenses lies with the Bureau of Real Estate. Question 130. Is the most important factor in determining a property's value? A. Design, b. Location, c. Utility, d. Age. Correct answer is B. Location. Location is still acknowledged as the most significant factor affecting property value. Question 131. The value of a property can increase significantly when its neighborhood includes lots and the houses built on them that are mostly similar in size and shape. Describes the a. Principle of substitution, b. First law of housing, c. Principle of conformity, d. Principle of progression. Correct answer is C. Principle of conformity. The principle of conformity states that the value of a property is maximized when it conforms to the design and features of the surrounding area, particularly the size and shape of the houses. In other words, properties that are similar in appearance and style to their neighbors tend to be more valuable. Question 132. The following occurs whenever a payment is made for an amortized loan. A. The amount applied to the principal rises. B. There is a balloon payment. C. The amount applied to the principal remains unchanged. D. Both A and B. Correct answer is A. The amount applied to the principal rises. The balance of an amortized loan is reduced with each payment. Consequently, the interest portion of the payment is lowered and the principal portion rises with every payment. Question 133. The types of mortgage default insurance include A. Partial coverage, B. Full coverage, C. Co-insurance, D. All of the above. Correct answer is D. All of the above. Mortgage default insurance is typically required for conventional loans with a down payment of less than 20%. It protects the lender in case the borrower defaults on the loan, but it does not protect the borrower. Partial coverage covers a portion of the lender's losses in case of default. The specific percentage of coverage will vary depending on the program and the loan-to-value ratio, LTV, of the property. Full coverage covers the lender's losses up to a specified limit in case of default. This limit is typically the outstanding loan balance but may have limitations. Co-insurance is a shared risk arrangement between the lender and a private mortgage insurance company. The lender pays a portion of the premium, and the private mortgage insurance company covers a portion of the losses in case of default. The specific sharing arrangement will vary depending on the program. Another variety of coverage, self-insurance, puts the risk of default with the lender. Question 134. A trust deed with a balance of $75,000 was sold to a businessman for $50,000. Such a practice is called A. Liquidation, B. Discounting, C. Securitization, D. Remarketing. Correct answer is B. Discounting. If a deed of trust sells on the secondary market for less than face value, it is termed discounting. The businessman purchased the trust deed at a discount, which means he paid less than the outstanding balance. This is a common practice for investors seeking higher returns on their investment. There is inherent risk involved, as the borrower might default, and the investor might not recover the full $50,000 invested. Question 135. A plaintiff can ask a court to issue a writ of attachment against the defendant's property to satisfy the judgment being sought. The resultant attachment liens are a. valid for up to 5 years, b. not renewable, c. enforceable by the sheriff, d. none of the above. Correct answer is c. enforceable by the sheriff. Attachment liens are valid for 3 years, and are renewable. A writ of attachment empowers the sheriff to seize enough of the defendant's property to cover the judgment being sought by the plaintiff. Question 136. A good faith deposit could be a. a diamond ring, b. a promissory note, c. anything the parties agree has value, d. all of the above. Correct answer is d. all of the above. While a good faith deposit is usually cash or a check, it can actually take any form the parties agree on. Question 137. The land description method that relies on sections, townships and ranges is the a. recorded map method, b. social grid technique, c. government survey record, d. meets and bounds method. Correct answer is c. government survey record. The government survey method describes property through its location in a specific section, township, and range. Question 138. A mudslide leading to severe property damage would be an example of a. avulsion, b. erosion, c. soil decline, d. corrosion. Correct answer is a. avulsion. Erosion refers to the gradual loss of land through natural causes like property washed away along a riverbank. Avulsion means the sudden loss of land by an act of nature, like a mudslide. Question 139. Broker Gary arranged a second trust deed amounting to $9,000 for Raul, and asked Raul for a commission of $1,200. Gary's commission charge is a. legal, because Gary can charge whatever commission he chooses, b. illegal, because it is over the amount allowed by law, c. invalid, because the California Association of Realtors does not allow commissions for second trust deeds, d. legal, because it complies with allowable commission percentages for second trust deeds. Correct answer is d. legal, because it complies with allowable commission percentages for second trust deeds. According to the real estate law, a loan of less than $20,000 for a 3-year term or more can result in a commission up to 15% of the loan amount. 15% of $9,000 is $1,350, so the $1,200 commission charge is permissible. A second trust deed, also known as a junior loan or subordinated loan, is a type of loan that allows a property owner to use their property as collateral for an additional loan. The first loan is called the first deed of trust, and the second loan is recorded against the property that already has the first loan. The borrower keeps the existing mortgage, but can take out another loan against the property. Question 140. In their first meeting, an owner tells a broker that the property should not be shown to any persons of color. Upon hearing this, the broker should a. accept this listing under the reasoning, if the broker doesn't take it, another broker will, b. explain to the owner that there are less obvious ways to make sure the property is sold to the right kind of person, c. advise the owner that, if he wishes to discriminate against certain persons, then the owner should sell the property himself, d. refuse the listing. Correct answer is d. refuse the listing. Discrimination based on race, color, and other protected classes is illegal in the United States under the Fair Housing Act. Accepting the listing would make the broker complicit in this discriminatory practice. Real estate brokers have a professional code of ethics that requires them to treat all potential buyers and sellers fairly. Accepting a listing based on discriminatory criteria would be a violation of this code. For that reason, refusing the listing is the only option that protects the rights of potential buyers and upholds the broker's professional obligations. Question 141. A dam breaks, and the rush of freed water washes away most of a real property. This is called a. avulsion, b. accretion, c. reliction, d. rescission. Correct answer is a. avulsion. Avulsion refers to a sudden loss to land, resulting from the action of water. It differs from accretion, which describes a gradual addition to land resulting from water. Accretion is also known as alluvion. Question 142. Judgment liens and mechanics liens differ because A. Judgment liens cannot be enforced unless they are recorded. B. Mechanics liens are created by statutory law. C. Judgment liens are imposed involuntarily. D. Mechanics liens can take priority earlier than when they are recorded. Correct answer is D. Mechanics liens can take priority earlier than when they are recorded. Mechanics liens are enforceable dating back to the day construction was started, while judgment liens are not. Judgment liens arise from a court judgment against a debtor. It's imposed involuntarily, meaning the debtor has no control over the placement of the lien and require recording for enforcement. Mechanics liens created by statute to protect contractors and suppliers who are not paid for their work or materials. It filed by contractors or suppliers to secure payment. Can take priority over other liens even before recording. Question 143. The concept of latches in real estate matters relates to A. Door locks. B. Water rights. C. Quality of construction. D. Failure to bring a claim in a timely manner. Correct answer is D. Failure to bring a claim in a timely manner. Latches is a legal principle in California real estate law that prevents property owners from delaying claims about their property for too long. It's an equitable doctrine that allows courts to deny relief to a claimant if they unreasonably delay asserting their claim. The justification for the doctrine is that the delay was unreasonable on the part of the plaintiff, and the changed conditions due to the delay render granting the relief sought inequitable. If the delay on the plaintiff's part can be satisfactorily explained by some reason like lack of information, the delay may be excused. Question 144. In this type of listing, the seller pays a commission to the broker even if the owner sells the property himself. A. Exclusive agency listing. B. Net listing. C. Open listing. D. Exclusive right to sell listing. Correct answer is D. Exclusive right to sell listing. This type of listing provides the greatest commission protection for the listing real estate broker. The seller agrees to pay the listing broker a commission no matter who procures the buyer. This type of agreement also benefits the sellers, as brokers will naturally put more effort into marketing a property where they are guaranteed a commission if there is a sale. Question 145. Under the UCC, in contracts for the sale of goods, the test for deciding whether a buyer has the right to specific performance is if the items being sold are A. Expensive. B. Readily available. C. Unique. D. Both A and C. Correct answer is C. Unique. If the buyer purchases a unique item from the seller and the seller breaches, specific performance will be awarded and the seller will have to produce the item for the buyer to possess. Question 146. The following are ways that staging is used to improve the desirability of a home being shown to potential buyers, except A. Removing clutter. B. Replacing window shades. C. Upgrading earthquake insurance. D. Eliminating food odors. Correct answer is C. Upgrading earthquake insurance. While confirming the adequacy of home insurance for a house on the market is advisable, staging is concerned with highlighting a home's strengths and downplaying its weaknesses in ways that are visible to visitors. Question 147. A potential borrower trying to obtain a FHA loan would apply to A. A broker. B. The FHA. C. An approved lender. D. The VA, if the borrower is a veteran. Correct answer is C. An approved lender. The Federal Housing Administration, FHA, doesn't directly lend money. The FHA is a government agency that insures mortgages, not a lender itself. Approved lenders process FHA loans. Borrowers must apply for FHA loans through lenders approved by the FHA to participate in the program. These lenders can be banks, mortgage companies, or credit unions. Brokers can connect borrowers with lenders. While brokers can't directly issue FHA loans, they can work with borrowers to find an FHA-approved lender that meets their needs. Question 148. Bart, an owner of beachfront property, is aware that the paved pathway to the beach being constructed over the course of a year by Jared, who lives across the street, is an encroachment on Bart's property. Nevertheless, Bart waits until the pathway is completed before notifying Jared that Bart is suing to have the pathway removed. Jared can likely prevent this result by relying on the grounds of A. Laches, B. the statute of limitations, C. the statute of frauds, D. Coastal Commission regulations. Correct answer is A. Laches. Laches is a legal doctrine that can be used by courts to bar a claim because of undue delay in making that claim. Question 149. The appraisal method usually relied upon by real estate professionals is the A. Cost approach, B. Capitalization approach, C. Market approach, D. Sales replacement. Correct answer is C. Market approach. The market approach, also called sales comparison, is the most commonly used by appraisers for vacant land and single-family homes. Question 150. Harry makes a written offer to purchase real property, but before learning whether the seller accepted it, Harry is killed in a car accident. What effect does Harry's death have on the offer? A. Once the administrator of Harry's estate is notified of the seller's acceptance, the contract is binding on the estate. B. Regardless of the timing of notification, the offer and its acceptance create a valid contract. C. Harry's death served to revoke the offer. D. If the car accident resulting in Harry's death occurred after the offer was accepted, it is binding on the estate. Correct answer is C. Harry's death served to revoke the offer. If either party to a contract offer dies, it terminates the offer.